You're listening to Joe Rogan Experience with Lostash. I'm just kidding. This is still the Lostash channel, and I'm Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. A few years ago, I published a video, Lange versus California. This is a case from 2021, and it dealt with the hot pursuit of an individual who just committed a misdemeanor. And the question was, can the police make a warrantless entry into a home to make an arrest? If you don't remember the case, don't worry about it. Watch it after this video. I will link it in the description below. Today we're going to discuss a similar situation. This is something you already know. If the officers have reasonable suspicion that you're committing a crime, they can pull you over. If you're driving a vehicle, of course. Now, remember, this is a pretty low threshold. Only reasonable suspicion. But the crime we're talking about is something that's happening right now. What about if the officers believe or have reasonable suspicion that you have committed a crime in the past? Well, it will depend whether that crime is a felony or a misdemeanor. And today we're going to focus on those old crimes, misdemeanors only. Here we have a case where a neighbor calls on his neighbor who apparently for years has been driving next to him and really driving him insane. This individual was driving with loud music, and so the neighbor called the police to report excessive noise. And later the officers tried to pull over this individual on reasonable suspicion that he has previously played loud music. Can they do that? We'll find out. But before we go on, I want to thank you for watching me on YouTube, hitting that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lostash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lostash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lostash YouTube page. That's L-A-W-S-T-A-C-H-E.
Today we're discussing a Ninth Circuit case, United States versus Grigg. And it deals with the question whether police officers can pull over a vehicle for past misdemeanors. But first, let me give you some factual background. A neighbor calls the police and says that there was a vehicle driving next to his house with excessive noise, playing loud music. Two officers get dispatched to the scene. They're driving two vehicles, so they get dispatched independently. As they're talking to this neighbor, he says that kids in the neighborhood have been harassing him for years. They always drive by his house with loud music blaring through the windows. Now, the officers are taking the report. They also find out from this neighbor that the individual has called the police on prior occasions. The neighbor also tells the police that on one of the occasions, he actually filed a police report. Now, while one of the officers is filling out an official complaint, the neighbor points to the vehicle down the street and says that that's the vehicle that's been making the noise earlier in the day. As the officers are talking to the neighbor, Mr. Grigg gets into the vehicle, drives from his house, past the officers and the neighbor, but at this point, he's driving lawfully. There's no noise or loud music coming from the vehicle. He simply drives by. Now, one of the officers makes the decision to get into his patrol car and follow Mr. Grigg. He pulls him over. And as he gets to the vehicle, Mr. Grigg tells the officer that he has a hunting rifle in the vehicle that he's been taking to the shop to fix. Now, the officer sees the firearm in the front seat. He also sees some ammunition. Mr. Grigg is later charged with possessing a firearm that's not registered. Now, later on, during the suppression hearings, the officer testified that he never had an intention to arrest Mr. Grigg. In fact, in the state that this happened, officers are not permitted to arrest individuals for misdemeanors that happen outside of the officer's presence. So here, lawfully, the officer even couldn't arrest Mr. Grigg. He also later testified that he never did anything to figure out whether it was in fact true that the neighbor filed any complaints against Mr. Grigg. Well, the officer didn't know Mr. Grigg's identity until he pulled him over. He also said that he decided not to look through his computer system because it would have taken him too long, and that he didn't call the dispatch because he quote-unquote didn't want to bother them. He said that after all, this was an excessive noise, and it wasn't such a big deal. Well, it became a big deal. And here, Mr. Grigg filed a motion to suppress the firearm, saying that the officer should have never pulled him over. And this detention was a violation of Mr. Grigg's Fourth Amendment rights. We're now in the Ninth Circuit, and the question becomes whether the officer can pull over an individual with reasonable suspicion of a past misdemeanor crime. Most of the constitutional principles at play in this appeal are well established. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Under Terry and its progeny, police may, consistent with the Fourth Amendment, stop persons in the absence of probable cause under limited circumstances. In particular, law enforcement officers may briefly stop a moving automobile to investigate a reasonable suspicion that its occupants are involved in criminal activity. However, the government interest in investigating possible criminal conduct based on an officer's reasonable suspicion may be outweighed by the Fourth Amendment interest of the driver in remaining secure from the intrusion. An investigatory stop can be undertaken to prevent ongoing or imminent crime. That is, when an officer observes unusual conduct which leads him reasonably to conclude, in light of his experience, that criminal activity may be afoot. Further, in Hensley, the United States Supreme Court held that if police have a reasonable suspicion grounded in specific and articulable facts that a person they encounter was involved in or is wanted in connection with a completed felony, then a Terry stop may be made to investigate that suspicion. The Hensley court explicitly confined its analysis to the felony context, leaving open the question whether the rule could be extended to all past crimes, however serious, that is, misdemeanors. Thus, the Supreme Court's Hensley decision did not answer the issue tendered by this appeal. Grigg's challenge to the district court's extension of Hensley raised an issue of first impression before us. First, let's acknowledge that a stop to investigate a completed crime does not promote the same interest of crime prevention as an investigative stop of an ongoing criminal activity. That makes sense, right? If the officers see somebody committing a crime, of course they should pull over that vehicle. But we don't have the same interest if the crime has already been completed. And here, the second distinction, of course, is felony versus misdemeanors. Let's briefly talk about Hensley. This was a case where the officers suspected two men of an armed robbery, a very serious felony. And in fact, Griggs argues that Hensley is distinguishable on its facts because the case concerned a completed felony, an armed robbery that presented a significant public safety risk, whereas Grigg's suspected misdemeanor noise violation is a minor nuisance. And the court agrees. The court says it is difficult to imagine a less threatening offense than playing one's car stereo at an excessive volume. The absence of any danger to any person arising from the misdemeanor noise violation here does not support detaining the suspect as promptly as possible. Despite felony misdemeanor distinction, the court does not adopt a per se rule that all past misdemeanors cannot provide reasonable suspicion for the officers to pull over a vehicle. Instead, here's what the court says. We adopt the rule that a reviewing court must consider the nature of the misdemeanor offense in question, with particular attention to the potential for ongoing or repeated danger, for example, drunken and/or reckless driving, and any risk of escalation, for example, disorderly conduct, assault, domestic violence. An assessment of the public safety factor should be considered within the totality of circumstances when balancing the privacy interest at stake against the efficacy of Terry's stop, along with the possibility that the police may have alternative means to identify the suspect or achieve the investigative purpose of the stop. Now that we know the rule, let's talk about this case. And first, let's start with public safety. Of course, we're talking about a noise ordinance, and it really shouldn't spur the police into instant action. We're dealing with a very minor offense. This is not a serious felony, and this is not even a serious misdemeanor. And second, let's talk about the alternative means to investigate this crime. First of all, the officers could have went through their logs to try to figure out who owned the vehicle, because after all, the neighbor said that he has previously made calls to the police. Now, the officers said that it would have taken them too long to figure out through the logs. But there was a second way, much simpler. They could have simply let Mr. Grigg go on his way and instead go to the house where the car was previously parked, knock on the door, and talk to the occupants and figure out who drove the vehicle. Maybe the person living in the house would have simply volunteered that information. And known that information, they could have left a citation or maybe a warning at the house, or at the very least, they now would have known who Mr. Grigg was without pulling over the vehicle, without any reasonable suspicion. So at the end of the day, we now know the rule. If we're dealing with misdemeanors, it really depends on the misdemeanor and how serious it is. So if we're dealing with something like drinking and driving, or assaults or batteries, perhaps the officers can pull over that vehicle. But if we're dealing with something as little and petty as a noise ordinance, no, the officers cannot pull over that vehicle. So I hope you learned something here, and if you did, please give my video a thumbs up. Please subscribe to my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to losthash.com and check out my merch, including the Do Not Arrest This Person t-shirts. I will see you next Wednesday for another video where we go into a deep dive on a case, and this upcoming Friday where I'll discuss some of the big news in the criminal defense arena during this week. Thanks for watching.